either misconduct, malfeasance, nonfeasance, crimes in office, drunkenness, gross incompetency, corruption, theft, oppression, gross partiality. And then further it goes on to state, the petition shall contain a specific statement of specific statement of the grounds on which the removal is sought. Okay, so that's not from the Attorney General's opinion, that's from the SDCL. So it sets out a different standard than the referral provisions set up.
But you
And so,
haven't,
since that, just a minute, since that's in there, you know, there's a provision or a legal doctrine that's cited regularly in interpretation of statute, and you can find references to it across and from any jurisdiction that you want. And what it essentially says is that the legislature doesn't write language in the statute that is superfluous or simply meant the legislature means what it says. And so if these provisions are really not really intended to be scrutinized once 15% of the voters have signed on to a petition, then they wouldn't be in there. The effect of a recall is a little bit more than a referral to just, well, we disagree with what the city council did, we want to refer the matter, we went out and got our 5%. This is intended to be more than simply disagreeing with the mayor. This is intended to be, there's got to be some pretty specific grounds that have to be met here, because otherwise, and I think that when you're talking about the legislative history starting back in, what was it, 1903 or 6 or whatever the heck it was, at that point there wasn't any, those grounds weren't included in the statute. You said you go out and get your 15% of the voters and away you went. And I imagine that probably over the last century that there have been revisions to that statute that have kind of tightened it up, made it a higher threshold to clear before you can have a recall election, is probably because the legislature intends this not to be an alternative regular election, a political election. If the voters don't agree with me and you, we stand election every 2 years.
I agree. And
If you throw these provisions out, we stand election every time a group of people doesn't agree with us.
But here's what I'm trying to get at. You haven't cited anything that says the city council's opinion is needed in this matter. But what you did say was that there's great specificity in what work they did do. I mean, there's a fair amount of detail in here, and I agree, this rises to a higher level. You need a higher threshold of signatures on the petition. So I'm curious, when this was drafted, number one, with the seriousness of it, why they would leave out the governing body's opinion, and why, I mean, they could have easily put it in.
I think because it's intuitive, it's implied. It says here that
It's not implied, no, it says within 10 days after presentation of the petition to the governing body, then they easily could have put in, the governing body shall decide if it rises to the level, and then fix and set a date.
You're reading the municipal code paraphrase.
You haven't read me
of the
anything that
statute.
states different than this.
What it says, 9/13/31, do you have a copy of
No, I don't.
9/13/31?
Larry gave it to us.
I guess I do.
9/13/31 says, and that's the point I was trying to make before, is that, yes, the governing body upon being presented with a petition, will schedule that election within 10 days, but it's a petition pursuant to 9/13/30.
You got your friend?
Here it is.
You got it? So, it's not merely just having a petition with the requisite number of signatures presented, it has to be a petition pursuant to 9/13/30. And 9/13/30, in addition to setting out the requisite number of signatures, also states the grounds. Now, we can, this petition sets out 9 different claims supporting 2 different grounds. We can call a black and white dog red if we want, but it's still black and white if it's black and white. Somebody's gonna make this decision, regardless of what we decide here tonight. Somebody's gonna sit in review of what we've done here and decide whether these grounds were or were not met. If this council decides that the grounds were not supported by the claims, then somebody is probably going to sue the city. If this council decides that the claims do support the grounds, then the mayor is likely to sue the city. A judge will then decide. So it's not so simple as just saying, well, 15% of the voters took and signed onto a petition, so we have to do what that 15% says, notwithstanding the fact that there might not be sufficient claims supporting those grounds. Because if we just go to work and decide that, maybe the mayor will sue us, seeking a writ of prohibition.
I agree that somebody eventually will decide this. But what you cite in 913-30 doesn't reference the governing body.
It does in 9/13/31.
But that's not what Bill was talking about. Bill was talking about the specificity in 913-30, and it doesn't reference the council.
Yes, yeah, in fact, let's just read through it. Petition signed by 15% of the registered voters of the municipality based upon the total number of registered voters at the last preceding general election, demanding the election of a successor to the mayor, commissioner, alderman, trustee sought to be removed, shall be filed with the auditor, presented by the auditor to the governing body. And it goes and it states the allowable grounds which we discussed.
But that's been done,
Yeah,
correct?
right.
That's been done.
Then the petition shall contain a specific statement. That's what we have to address here.
But it
Now,
makes
go
no
down to-
reference to
go down
who
to
passes
nine-
judgment on it.
Go down to 9/13/31, special election or recall petition. The governing body shall, upon the presentation of a petition pursuant to 9/13/30, within 10 days, fix the date, and so on and so forth. Well,
So
that
you would
implies
argue,
that just a minute, that implies that the governing body has to make that decision. Who else is gonna make that decision? Is Teresa gonna make that decision? I
So-
think her function here is ministerial.
so your argument would be,
Guys, I think we've stated each other's side.
Well, Doyle, just, let me say this.
Just a second, I'm gonna let Mark speak first, because I interrupted you, so.
so your argument, Bill, would be that the governing body shall, upon the presentation of the pursuant, so you're saying 31 references 30,
Absolutely.
and so the council, the governing body's referenced in 31 to pass judgment on 30.
That's correct.
That's what
I'm
you're,
reading the two statutes together.
Okay. Would that be your opinion, Larry?
What's that, Larry? Yeah.
I asked if that was his opinion as well.
Doyle, just let me say something here.
Can you hold one second, please?
I probably wanna expedite this and get home and figure out something else to do as much as anybody here tonight. But I think regardless of what decision this council makes, whether it's to validate the petition or reject the petition, we're creating a record here. Either way, we're creating a record here, and I don't think that we can shortcut that process.
Mr. Council President, I respect the city attorney's words earlier and him bringing up decisions that have been out there. I will quote to you from the same book that he quoted from tonight, and refer to 913-30. Decisions. The one decision which the city attorney spoke to is the last one that is mentioned here. If you'll give me the time, I'd like to read the rest of the decisions for you. It's about half a page at the most. In general, legislature has exclusive authority to determine whether privilege of recall elections shall be extended to voters of the municipality, and if so, on what terms and conditions and what manner. That's from State versus Birdall and Norstead, 1936. I think this next piece speaks to what the discussion was going on here. Sufficiency of petition. The statute representing municipal recall elections confers very broad discretion on auditors of municipalities in determining sufficiency of recall petitions. That again from the Birdall and Norstead case, 1936. Following legislature had power to leave questions of sufficiency of petition for election to recall mayor to city auditor, whose determination cannot be judicially reviewed or other remedial wit unless arrived at arbitrarily or in bad faith. That also from Birdall and Norstead in 1936. Then one filing petition for city election to remove mayor in office of city auditor who determined that the petition was insufficient as it was not signed by a requisite number of qualified electors. It was held not entitled, and then it was, of course, set aside. City auditor in ascertaining sufficiency of petition for recall mayor held not confined to the petition. And that is from the State versus Lease in 1932. And the city auditor, in determining sufficiency of petition for recall of mayor, acts in quasi-judicial capacity, and his determination is final except where he abuses his discretion. That, again, is a State versus Lace in 1932. Everything that I read up until that point says to me that the auditor makes the determination of the petition and whether it's sufficient. I do not read anything into any of those decisions that says the council or the governing body makes that decision. I read everything into that being the auditor. So I just bring that up as you guys were having this discussion back and forth and you're talking about legal situation. I just wanted to read those decisions.
Mr. Randall, is that the totality of the citations that you're?
Yes, the only one remaining is dealing with the case from New Underwood, which was from 1983, which was general assertions that mayor exhibited negative personality characteristics and that he harassed and intimidated city residents do not meet specificity requirements for recall petition.
Okay.
And that was the decision that Larry had spoken to earlier.
Okay, I'd like to respond, Mr. Randall. Those cases that you cited, the ones that are in relation to the determination of who the gatekeeper is, so to speak, whether it's the auditor's decision or what have you. Those cases were from 1932 and 1936, correct?
That would be correct.
Okay. The last revision to the statute that incorporated the grounds for removal, that being the misconduct, malfeasance, nonfeasance, crimes of office, drunkenness, gross incompetence, corruption, theft, oppression, and gross partiality. Those did not become a part of the statute until 1968. So I would suggest to you that at the time that those opinions were written, all that was necessary was to have requisite number of petition signatures. And that certainly is a ministerial function. I would agree that the city auditor or city administrator could perform. But once the legislature incorporated grounds, that becomes more of a legal question as to whether those grounds have been established.
Fair enough.
Thank you.
You want it next? Okay.
Well,
Okay.
the Bergdahl case ended up being about a auditor that had looked at a petition and couldn't find the ballot signatures and said, no, we're not moving forward. Mayor said you can't do that, you don't have the power. The court said, well, that's implied, you can look at the petition to see what the threshold is. I will tell you that the auditor, in my opinion, has some functions here, and that we're first off deciding whether or not there were enough signatures presented. Were they valid? And you've heard the reports, that's part of her job. Had she said there were not enough signatures, we wouldn't be having a discussion at all. Second part of her job is to see that it was on the form prescribed by the Board of Elections, which it is. We compared it with the Board of Elections form. And because there were 8 or 9 over the number, 8 or 9 over the number, we're now here for you folks to go to what I call the next threshold, which does it do the specificity related to the Attorney General's office. And you may recall under the Attorney General opinion, if you look at it closely, it says that the petition was filed with the City Council, and the Attorney General then said, well, it doesn't meet specific requirements of the statute, you don't have to schedule the election.
Okay. Any other discussion?
Well, I guess I would ask the question, is there any single ground, claim among these 9 that meets the specificity requirement, is factually represented, and rises to the level of the ground state?
Okay. Yes.
Kathleen Puppin, if you need any specificity on if these grounds are justified, I have a camera full of video if anybody would like to find specific reasons on any one of the 9
Well,
reasons that have been.
Ms. Putman, the problem is that the video is not in the petition. We have to consider the petition based on what's in the 4 corners of the document, because that, after all, is what the signers were looking at.
So answer me this, sorry, I didn't mean to cut you off. We could specify it, and you would say prove it, but I can't give you a picture unless you want me to lay out every single snap. I mean, they all break down into little digital snap pictures. Does it need to be on a little picture book?
Well, let me give you an example.
Okay.
So let's just look at this number 4 under oppression.
Mhm.
The mayor has consistently refused to allow citizens to address the council at open meetings. Well, there certainly is one individual here who was not afforded an opportunity to address the council at an open meeting. Beyond that, I'm having a difficult time coming up with an occasion when somebody wasn't afforded an opportunity to speak, that wanted to speak, let alone a consistent pattern. Consistent pattern would mean like, well, every meeting or so,
Well,
somebody doesn't get to
consistent,
speak.
that exact meeting,
But-
yeah, that
but-
exact.
But, be that as it may, if you have specific dates and times when the mayor did not afford somebody beyond the one time that was clear, then that should have been stated here in the petition. You're explaining to me now when these events occurred.
We all know when they occur. You
Well, I
know
don't,
as well
because
as do.
because I'm being perfectly honest with you when I'm telling you, I
Who do
can't
these need to be
remember.
specific for,
more
when
than
you all
one.
already know, you already know.
I can't remember more than one occasion, and the one occasion is very clear, when somebody wasn't afforded an opportunity to speak. You said that well, not you, but whoever put this petition together is saying that consistently, regularly, persons don't get to speak. If that in fact is the case, then that should have been stated on such and such a date. This person didn't get to speak, such and such a date, that person didn't get to speak, such and such a date, that person didn't get to speak. Because otherwise, this is rather vague and ambiguous.
Would you agree with that, Counselor, that those specific examples should have been included within the petition? Or can we rely upon memory to,
The statute's pretty clear, shall state the specific grounds, right? And the Attorney General's opinion is very clear, and says, shall state the specific grounds, all right? General doesn't work. I'm not gonna make the decision for you.
yep, thank you.
Mr. Mayor, may I address?
Yeah. It's Council President, sorry.
I'm sorry about that.
I have no intentions of ever running.
But you look so mayorly.
Looks are very deceiving.
A couple of points that I'd like to make as you move forward here. As the city attorney has said, the grounds have to be specifically laid out. If you look at 930, it lays out the grounds,
Yeah.
okay? So grounds are specifically laid out in the fact that you have two reasons, two grounds that are spelled out on the petition. They are then followed up by instances. Now, a petition needs to be one piece of paper, can only be front and back. You only have so much room, you cannot have a second page, you cannot staple things together, you can't tape anything together, it has to be front and back. If you lay out specific and call out exact specific instances, as were there would be no room for anybody to sign the petition. As far as the situation of people not being allowed to represent the council, yes, Mr. Councilman, my specific situation comes to your mind. My specific situation has been out there. My specific situation is the link to video, which is referenced in the petition. We cannot attach a video to the petition because it's video, the petition has to be paper. Yes.
Two things. Your specific incident, I don't believe is in dispute for anybody. What's in dispute here for me on this particular claim, supporting this ground, is that it's a consistent pattern. As I said, I can't come up with one other time, let alone a consistent pattern across multiple meetings, okay? So that's a factual issue. But as far as, yes, we've stated here that oppression is one of the grounds that you're seeking removal upon. Gross partiality is another ground that you're seeking removal upon. But with all due respect, again, these claims support those two grounds. By me, like I said to Mark, by me calling a red dog black and white, that does not make that dog black and white. It's still red. So these claims, they have to be evidenced that there has been oppression. These claims do have to indicate that there's been gross partiality. You've got a claim here under gross partiality that says the mayor declined numerous invitations to attend public forums on the EDD issue. Well,
Councilman, would you have liked me to that petition to say that that the mayor in public meetings said had he no intention on attending a public session? Because it's on video. Now, what I would like to come back to is the first part of,
just
sit down.
a minute before you come back to that.
I want to come back.
But, I'll let you come back to that. But what I think effectively is being said here, the mayor declines to attend a public meeting, well, is the mayor compelled to attend a meeting that is not sanctioned by the city? He's required to attend these meetings. He's not required to attend Chamber of Commerce, sponsored meetings. You know, he might have, for all I know, he might have decided that a forum that was being moderated by somebody that had clearly set out his position on the issue wasn't
Okay.
gonna be a fair forum. I don't know what
Here's
his
what
feelings.
I'll do for you there. I will concede that point, because it's a minor issue. I'll concede that point. One issue on this petition, if you're going to decide tonight, you need to decide if in fact one of them meets the litmus test,
Okay.
okay? The other one that you called out is one instance that you remember of someone not being allowed to speak.
Yes.
I would like to ask those in attendance tonight, how many in this room, since the mayor took office in May, have stood up and approached the council at a meeting and have been told they're to sit down or they're not gonna be heard at the meeting?
Well, that,
Now,
Mr.
now, where I will go with that, Councilman, is we have numerous instances, those instances have been recorded on video. I believe most of those instances are recorded on the council's archived video, which was not made available to the public, archived video which no one has been able to use as a piece of evidence is what happened at these meetings, okay? So that video not being available to be put into the evidence, you as the council are the only ones that have had access to that archived video. That's where those instances would be an evidence for you. There's evidence, it's stated there on a web link, which is or is not available at this point in time, but there is other video evidence out there. And do keep in mind, as you've sat at these meetings, if you have seen that activity go on at these meetings, any one of you, know that that video evidence is out there. And Mr. Haugen, as you brought up, there could be a lawsuit or litigation would go down forward. Keep in mind, if you believe that that would be out there as evidence, you need to consider that. Thank you.
Well, and I'd like to address you.
Sure.
Once again, as I sit here, and I believe I've been in attendance at, I think all but perhaps one meeting since I've been on the council. Don't throw me into the fire if I'm off by a meeting, but I think I've missed one meeting. I can't recall an occasion where somebody was told that he could not speak besides you. However, whatever you're claiming is on a video is not in this petition. And this petition is what was circulated for person's consideration. And it is the statute that says, it is the statute that says those claims shall be stated with specificity, and it is the Attorney General's opinion from the 1983 case that you cited that states that those claims will be stated with specificity. And that with regard to that item, it's not. And there's a factual question about that item.
Okay. That's all I have for you right now. Thank you.
Mark, before you start, just one thing. Okay, just want to clarify one thing, Bill. I'm paraphrasing here. I believe the code says that the mayor shall preside over meetings as he sees fit. Basically, correct?
Well, let's not paraphrase. I think somebody must
Okay.
have 983 here. Let's just read it.
Okay. I'll just read it off. The mayor shall preside at meetings of the council, but shall have no vote except in the case of a tie. He shall annually, from time to time, give the council information relative to the affairs of the first or second class municipality, and shall recommend for their consideration such measures as he may deem expedient. So if he deems that he does not want to allow someone to speak, under this, he has that ability. However, this council also has the ability to override him. So if he says someone cannot speak, we can overrule with a motion.
Which
Correct? Which we have done with Justin Ike, I believe. So that ability is here if we want to override him. So we are culpable as a council then for not overriding if this is in fact a true statement.
This isn't about you, it's about the mayor.
Well,
No, but it is about,
well,
I
in
mean,
fact,
because some of these things could apply to me just as easily, Eric.
Good.
but here's what the mayor is being charged with here is oppression. And I think what you're saying is that we always have the power to overrule the mayor. Now, once again, getting back to your specific incident, Mr. Randall, where you were not afforded an opportunity to speak. There's no disputing the fact that that occurred. But, and I have thought many times since that occurred, that, you know, if I had made a motion, if Mark had made a motion, if somebody on this council had made a motion, if you had said in the process of being gavelled down while you were on your way back to your seat, please, somebody make a motion, I'd like to speak. I think that it's likely that somebody would have made a motion in a second, and I think it's likely you would have had to speak.
Wow.
I
That never occurred.
I wanna,
Ultimately, the mayor presides over these meetings, but his authority to preside over these meetings is at the discretion of the council. And we all, when that incident occurred, we all sat on our hands and did nothing. We allowed it to occur.
the point that hasn't been brought up, and I'm just gonna use, for oppression, I'm gonna use the word unfair. Oppression is listed. Item number 2 references the video. And the part that makes it unfair, and if you'll all recall or watch the video, Eric Bartman spoke from his seat. Lisa Helbig spoke from the podium. Tony Randall got gavelled down.
And Mark spoke from the podium.
That is unfair. Because it's been long-standing that if you want to address the council, you take the podium.
But it doesn't have to be granted, Mark.
I'm
not saying it has to be granted. What I'm saying is that Eric Bartman speaks from his seat. Lisa Helbig takes the podium and speaks. And then the unfair part was that we're not going to talk to Tony Randall. We're not going to listen to Tony Randall.
Well, we're not talking about fairness, we're talking about oppression here.
Oppression is unfair.
Oh, well, oppression, I believe, is a lot higher threshold level than simply unfairness. I mean, if that's what the legislature intended, Mark, the legislature wouldn't have written the word oppression into the statute, it would have said unfairness.
If
in
you
the
don't
statute.
think two people's opinion, their option to be heard in front of a city council, and one person's opinion not being heard is not oppressing that person, That's the definition of oppression. I'll listen to you, I'll listen to you, don't care what you think. That's the definition of oppression. And you keep going back to, you know, I haven't missed maybe but one meeting, and I've never seen it more than once. We're not talking about the number of times it's happened.
Well, we are too, because the petition says it's a consistent pattern of
Oppression.
behavior.
Number 2, cites the videos. That's one time. That's the only one that matters. Can't be oppressed one time.
Okay, you know, he's been waiting at the podium for quite a while.
Oh, I'm good.
You know what, you wanna switch?
I'd like to hear what Mark's got to say, but just to.
I like to keep things kind of simple.
Well.
And when I read
Mark,
this-
Mark, before you do.
Oh, the wrong mark, that mark, go ahead.
That Mark over there.
You can have my time, Mark.
No, I've been waiting this long, I'm good.
The, once again, with regard to that specific incident, the mayor exercised that authority at our discretion. You did nothing, I did nothing. Nobody sitting here did anything. Could have, didn't. Don't we all need to kind of look at ourselves and see if we're all responsible for what happened there in a way?
Can we jump off this right when you say that, Mark?
Very good, thank you. When I'm reading, I'm kind of going back to what you talked earlier. I need to explain to me how you have a choice in having an election or not. Because when I read this, it says, upon being presented a petition, the governing body will decide on a date for an election. It
Mark,
doesn't
what are you
say
reading? What are you reading?
right here,
from there?
special election, 9/13/31. The governing body shall, upon the presentation of petition pursuant to, within 10 days, order and fix a date of holding a special election. I don't see here where it says might or might not, however you want to interpret it. It says you shall do it. Now you reference back to 30, and this calls out the ground. Nowhere in here do I read that you, the council, or the governing body, are the judge or the jury of the petition. The petition was filed, signed, and presented to you. Whether there's one factual or 3 or 2, the petition went out and
Mark, flip back to-
270 some voters said, we want to vote.
Mark, flip back to 31. Because who orders and schedules the election?
The governing body.
Right. So when you read those two statutes together, the governing body is presented with a petition that's pursuant to 9/13/30, and then has to schedule the election. So when reading those two together, someone's got to be the gatekeeper here. Is it Teresa? Is it the city administrator? Is it the city finance officer that's the gatekeeper here? Now, referencing the 1932 and 1936 cases, when there wasn't a legal question as to what grounds had to be met, there simply needed to be enough petition signatures to constitute a valid petition. Yes, I would agree.
The
audit-
petitioners made the accusation
Let me finish.
and signed it.
I would agree that in 1932 or 1936, a city administrator or auditor could perform a ministerial function, count the number of signatures, and decide whether you have a valid petition or not. But now, subsequent to that, other language has been added to the petition, and it states that there have to be specific grounds met. So somebody's got to make that decision. And when you read those two together, it's
Right.
clear to me that the legislature intended that the governing body has to decide whether they've got a petition pursuant to 9/13/30 or not.
And Mark, I'm with you. I'm not an attorney, you're not an attorney, so as a councilman, I have to rely upon my advisor, who in this case would be Counselor Nelson, for his legal expertise. And the way he reads it, and as the city attorney, he's telling me that based upon 9/13/31 and 9/13/30, we act as that gatekeeper. So that's how I'm going to move forward, because that's how I've been advised. Because I'm with you, I can read this and it doesn't necessarily make a whole lot of sense to me either, but this is not my expertise, so.
But nowhere in here does it say you get to decide if there's an election. And qualifying if the petition goes for an election.
I guess. for
What it
me-
says is, if presented to you, you shall set a date. So that's what I understand, and I didn't hear Larry actually say that you
Well,
could be the
Counselor
gatekeeper
Carden made it
and
very
say yes or
clear
no.
that when the petition comes forward, it's up to us, based upon these two statutes, to state is what's in the petition specific enough, and you laid out the three different pieces of criteria that we need to look at in order to schedule the election and move forward. Council Wardham looked right at Mr. Nelson and asked, would you agree with that particular statement? And he simply nodded yes. So for me, that's the affirmation that I need in order to move forward on this.
Okay. So Larry, they do have to make a decision as a board?
If you would look at the Attorney General's opinion, please.
No, I'm looking at this, the code. What's the code say they have to do or don't have to do? That's what I'd like to know, please. No, I'm good. I just want my question answered, please.
If you would look at the Attorney General's opinion, it notes that the petition was presented to the City Council, who asked the Attorney General, do the grounds satisfy the requirement for the recall petition? The Attorney General said no. And I'm reading into the case that while they did go ahead and schedule the election, I believe the statute has had the mandatory shall schedule the petition for some time. And if the petition said absolutely nothing and we were all on board, that didn't happen, I don't think any of you would vote to schedule the petition. So from that perspective, I believe it's gatekeeping.
Council President, can I address the council?
Sure.
Okay. I guess I have a few questions based on opinion. First of all, either Bill or Larry can answer. With all this being kind of based on opinion, you say that you have a decision based on new language has been added in, what'd you say, 1968, that supersedes 1932 where the auditor holding the power. Where's the statute that's been written since 1968? Can you cite one for us saying that you do in fact have the decision to make, you don't just have to set a date? Because if a statute hasn't been written in, 47 years, wouldn't we still refer back to the last one that actually is recorded, which would be in the 1930s?
Well, Travis, the statutes we're reading from are more current than the 1930s. We're reading from the statutes that, what's the most recent amendment, the 30?
You cited though the 1968 one, and you specifically said that that's because that language was added in 1968, that supersedes the 1932 and 1936 language. But there's been no, what was written in 1968 actually says nothing about that the governing body actually has a decision to accept the petition or not.
What I said earlier is that you have to read statutes together. You can't just pick them out and piecemeal them. You have to read them together. And you got two neighboring statutes here. One that governs what a valid petition is, and two, when the election is going to be scheduled if there is a valid petition. And when you read those two together, and I think we've been down this path before, it's implicit in those statutes that the governing body here is the city council, and the governing body is the gatekeeper, so to speak. And that's what legal counsel here is telling us. Now, you can disagree with
But
it.
again, that's
But that's
opinion,
what-
there's
that's what
still
we're
no
using.
statute
And
that
again,
says.
Travis, I understand your opinion,
Okay,
and I guess maybe we can bury this one and move forward. If someone on the council feels as if we don't have an option to make a decision, that we have to move right into setting a date.
I already made the motion.
Motion's right on the table,
That's what started the conversation.
I forgot the date.
can I address Larry specifically, are you guys okay with that on one particular issue? Okay, and you quote now that it's the Attorney General's opinion from the 1983 that that petition wasn't specific enough. So, right, is that how you stated it? But didn't someone have to take it to the Attorney General first?
The person that requested the opinion was then Representative Walter Dale Miller.
Okay.
Ended up being the governor.
Yep.
And he requested the opinion of Mark Myring,
Okay.
attorney in Sioux Falls, and was the Attorney General at that time. This is the petition, this is the decision that was
Okay.
handed down as the Attorney
Yep.
General's opinion.
And that's all fine. So if it's the Attorney General's opinion, do any of you know what the Attorney General's opinion of this particular petition would be? Does it come down to opinion, or do you, because again, I believe I signed the petition. I believe